Okay, welcome everyone to the Joint Judiciary and Labor and Technology Committee hearing this 9:30 on Tuesday, March 19. Let's see, are you okay with a 2-minute time limit?
Yeah.
Okay, so testimony will be limited to 2 minutes, but if you can stick around, members will often have questions for you. First up on this 9:30 agenda is HB 1917. This appropriates funds for collective bargaining cost items for judiciary employees and their excluded counterparts. First up on 1917 is Eric Tanigawa for Human Resources, the Human Resources Director for the Judiciary. In support, Kalani Warner for United Public Workers, State Director. Morning.
Morning. Chair Rhodes, Chair Aquino, Kamakana Kaimala, UPW. You have a written testimony in support. We just want to highlight the fact that the agreement that we reached with Judiciary for THP last year is contingent upon the availability of funds provided by the legislature. We know that given the recovery efforts in Maui, money's tight, but we hope that the committee will pass out this measure so that we can make our folks whole who are in THP. Thank you very much.
Thank you. That's everybody who signed up to testify in HB 1917. Does anybody else wish to testify in HB 1917, either on Zoom or in person? Seeing none, members of both committees, any questions? I have none either, so I'll turn the mic over to Chair Aquino.
Okay, thanks, Chair. Okay, up next we have House Bill 1967, House Draft 1, related to the Human Trafficking Victim Services Fund. Okay, up first we have the Office of the Attorney General.
Good morning, Chairs Aquino and Rhodes. Valerie Mariano, Acting Administrator for the Crime Prevention and Justice Assistance Division. The Department of the Attorney General supports this bill and changes the administration of the Human Trafficking Victim Services Fund from the Department of Labor and Relations to the Department of the Attorney General. So points are also contained in our written testimony. So we respectfully ask the committees to pass this bill, and thank you for the opportunity to testify.
Okay, thank you very much. Okay, up next we have Giovanni De La Cruz. Okay, Department of Labor and Industrial Relations, OCS. Okay, support Rainbow Family 808. Okay. Jeannie Ota, co-chair, State Democratic Party of Hawaii, Women's Caucus. Okay, in support, Imua Alliance, Shannara Casey Richmond, Joy Dillon, late testimony from Dara Carlin, Lynette Honda, and also late testimony from Fran Inafuku. Okay, all in support, and the Office of Hawaiian Affairs. Okay, also in support. Any others wishing to testify? Oh. Oh. Okay. Thank you very much. Any others wishing to testify? House Bill 1967. Seeing none, members, questions? Okay, no questions. Moving on to the last measure, House Bill 1643, House Draft 1. Relating to indebtedness. Okay, up first we have DAG's Comptroller.
Good morning, Chairs, Vice Chairs, members of the committee. My name is Lydia Nash. I am the Administrator for the Accounting Division of the Accounting and General Services. We have submitted testimony on behalf of Keith Regan, the Comptroller, and stand on our testimony, and I'm here to answer any questions that you might have.
Okay, thank you very much. Okay, up next we have United Public Workers.
Here's right there, number.
Okay, thank you very much. Okay, also we have HGA.
Good morning, Chairs, Vice Chairs, members of the committee. Nui Sebas with HGEA. You have our written testimony, so we'll just stand on that. Available for any questions. We're in support. Mahalo.
Okay, thank you very much. Any others wishing to testify? Okay, seeing none, members, questions? Okay, Vice Chair.
For days. You know, I know that that's difficult in terms of your processing of time and finding people who you overpaid. But hearing from the unions and on behalf of their employees of coming, you know, how it impacts on them in terms of the monthly payments and having some way of graduating the payments in installments or something. Is there anything that you've thought about to lessen the impact on employees who you're going back for overpayments over the time period of this statutory limitation of 2 years?
You mean when we discover the overpayment? So we do try, well, the departments are kind of in charge of the overpayments to schedule out what the overpayment schedule will look like. So they try to talk with the employee to figure out what they come to an agreement to what they want to pay back. And there is a minimum right now of 100. So if they can meet that minimum 100, then that's what we do right now.
So if we reduced it as the bill suggested, $50, is that a burden on the system, or can that be done?
The system, it can calculate that. It's just going to lengthen the amount of time to recover the overpayments.
So is there any amendment that you have that they can pay upfront for what they can afford, and then having some way of graduating the payments so that it isn't impacting if they make minimum amounts in their paycheck?
Right, the system can accept what we put in as what we're gonna, the schedule that we come up with the employee.
So the bill as written will allow to do that, or is there any amendment to the bill that will assure that there is that kind of flexibility for?
The one thing in the bill that was in question was the gross income with those amounts that are in the tiers. So if the employee has other deductions coming out, like child support or other things, we would have to use that gross income instead of after the child support or after the other deductions coming out too. So that might be an adjustment that could be made with the bill. But that $50 is going to significantly lengthen the amount of time, yeah.
I guess I can see where we want the indebtedness to be off their indebtedness, but also how can we do it more efficiently? And I just wanted to know whether DAGs had any suggestion. The bill itself says you have to do it within 60 days, and can you do it then?
The 60 days upon discovery.
Yes.
Right, so it can be programmed into the system. We would have to meet with the employee first, or the department would meet with the employee first to figure out a payment schedule. And then
So
put it
the
into
bill
system.
as written is okay then?
It can work in the system, yes.
Thank you. Thank you, Chair.
Okay, members, any other questions? Okay, seeing none, do we need to recess? Bless you. Okay, let's go directly into decision making.
Okay, having heard the testimony, let's go back to the top of the agenda to do some decision-making. HB 1917 is the first one up. This appropriates funds for collective bargaining cost units for judiciary employees and their excluded counterparts. The recommendation here is to pass it with a different effective date, so April 14, 2112, since we don't know what the final number is at this point, as far as I know. Questions or concerns? If not, Senator Elefante for the vote. Thank you.
Okay, Chair's recommendation to pass with amendments HB 1917 HD1. Chair Rhodes.
Aye.
Vice Chair Gabbard is excused. I vote aye. Senator San Buenaventura.
Aye.
Senator Awal.
Aye.
Mr. Chair, recommendation is adopted.
Okay, Labor and Technology Committee, same recommendations. Any questions or concerns? Seeing none. Vice Chair for the vote, Chair votes aye.
Vice Chair votes aye. Senator Hara excused. Senator Lee excused. Senator Bella.
Aye.
Recommendation adopted.
Okay, thank you very much, members. Moving on to House Bill
We still got
1967.
to vote, sorry. For JDC, same recommendation.
Oh no, that was on the first one, Chair.
Oh, I'm sorry, you're right, my bad. Go ahead.
Sorry. Okay, so House Bill 1967, House Draft Fund relating to Human Trafficking Victim Services Fund. Members, the recommendation is to pass this as a SD1 with some technical amendments and a new effective date of July 1st, 2050. Questions or concerns, members? Seeing none, Vice Chair for the vote.
All members present, anyone voting no, anyone with reservation, recommendation adopted.
Okay, now it's my turn. Same recommendation for JDC. Any questions or concerns? Seeing none, Senator Elafante.
Okay, Chair's recommendations to pass with amendments, HB 1967 HD1 of the 4 members present on judiciary. Any no votes? Any votes or reservations? Hearing none, Mr. Chair, recommendations adopted.
Okay. On to the next or last, House Bill 1643, House Draft 1 related to indebtedness. Members, recommendation is to move this as a Senate Draft 1 with some technical amendments, the effective date of July 1st, 2050. And we're also going to be making some changes on page 1, line 8 to reinstate the 2 years regarding notification and determination. Okay. Questions or concerns, members? Seeing none, Vice Chair.
All members present, anyone voting no, with reservations, recommendation adopted.
Thank you. Same recommendation for JDC members. Questions or concerns? Seeing none, Senator Elafante.
Okay, Chair's recommendations to pass with amendments, HB 1643 HD1 of the 4 members present. Any no votes? Any votes or reservations? Hearing none, Mr. Chair, recommendations adopted.
Thank you.
Thank you very much. We're adjourned.
So JDC members. All right, welcome everyone to the 9:55 agenda joint between Judiciary Committee and Health and Human Services. Is 2-minute time limit okay?
Yes,
Okay, so we have a 2-minute time limit on testimony, both oral and on Zoom. And the first and only bill on the list is HB 1976, which requires the Office of Elections to annually request funding for the statewide elections accessibility needs advisory committee. First up on 1976 is Dane Street Bartolos, Executive Director for the State Council on Developmental Disabilities.
We'll stand on our testimony in support.
In
Thank you.
In support. Thank you. Kathy Best, Director for Department of Human Services, State of Hawaii. DHS. With comments, next is Kirby Shaw, Executive Director for Disability and Communication Access Board. In support, Louis Erdachek, Executive Director for Hawaii Disability Rights Center. In support, James Gashel for himself, but he's also Vice Chair of Statewide Elections Accessibility Needs Advisory Committee.
And Federation of the Blind.
And Federation of the Blind, I believe, yes. Good morning.
That's right. Good morning. Thank you, Chair Rhodes, Chair San Buenaventura, Vice Chairs and members. I'll keep the 2 minutes in mind. I just wanted to point out the importance of this, what we think would be just a small appropriation. Voter outreach and voter education around the area of accessibility is very, very important. We rightfully emphasize vote by mail, and that's a great system, but it does have some accessibility challenges. I'm one of those because you send me a print ballot, it's an unidentified print object, and I can't mark it and return it and like that. So our committee works on things like this. We need to do some outreach. We've been working with the Office of Elections on improving the technology around accessibility, but now we need to get out and work with the community more to learn more about the needs. So mahalo for having this hearing and hopefully moving this bill forward.
Thank you very much. Next is Kaiwi. In support, okay. Patricia Morrissey, Chair of the Statewide Elections Accessibility Needs Advisory Committee. In support. Sherry Shimizu in support. Katie Kine in support. Eleanor McDonald in support. James Labria in support. That's everybody who signed up to testify in person or on Zoom for HB 1976. Would anyone else like to testify on HB 1976? Seeing none, members, questions? I don't have any questions.
No questions, but we don't have quorum, but you have quorum.
Okay, we'll go ahead and vote and, you're okay with, okay, here was my
Yes,
suggested
what you
recommendation. We'll go ahead and put the $10,000 appropriation in, and we'll make it effective July 1, 2024.
Oh, terrific.
Okay?
Yep.
Okay. So that's the recommendation for JDC members. Move it forward with a $10,000 appropriation and effective upon July 1, 2024. Questions or concerns?
Oh, yeah, I guess my question is, if it's effective July 1, 24, will Office of Elections be able to do it by the primary in August?
I have no idea. I mean,
And
the
there's
money
somebody here,
would be there, so presumably they could move forward, but,
hopefully. Okay. As soon as practicable
Yep.
anyway,
right.
at least hopefully by general.
Other concerns? If not, Vice Chair Gabbard for the vote.
Chair's recommendations to pass HB 1976 with amendments. Chair Rhodes.
Aye.
Vice Chair votes aye. Senator Elafante excused. Senator San Bonaventura.
Aye.
Senator Owa excused. The measure passes.
Thank you.
Okay, so for HHS, we're gonna, since we have no quorum, we will defer decision-making to the HHS calendar of March 20th at 1:01 PM in conference room 225. And we know what your proposed amendments are, but so thank you very much. So
Thank
we
you.
are adjourned for this session.
We're adjourned for the
Thank you for
9:55.
sticking
Okay, welcome back. We have two 10 o'clock agendas. I'm going to go ahead and pick up the one that has HB 1884 on it to start with. This is a decision-making on a bill that we've already heard, and I'm going to defer it until Friday, March 22 at 10. It's a single, so we do have, by legislative standards, we have lots of time. So that one's deferred to March 22 at 10 in this room 016. Okay, leaving that agenda and going on to our other 10 o'clock agenda, we will start with HB 2058 relating to dangerous dogs, establishes requirements and penalties for owner of dangerous dogs. This one we started hearing, I forget what day it was, last week sometime. And so we've heard quite a lot of the testimony on it already. Okay, so that was her. She testified already, right? Okay, so let's start with her. Okay, so we did hear quite a lot of testimony on HB 2058 already, so we're going to resume where we left off. And so next up is Teresa Tico on Zoom. We hope.
Thank you. Thank you very much, Chair. My name is Teresa Tico. I'd like to thank the chair and committee members for allowing me to testify. I had a computer glitch last week and somehow missed the opportunity. So I appreciate that you continued the hearing to allow others to testify in support of this very, very important bill. I'd like to say that I've been an attorney in civil law practice on the island of Hawai'i for 47 years. I've been a per diem judge, president of the Kauai Bar, counsel to the grand jury. I have a lot of experience in the legal world. Throughout all of these years, I have usually had one or two dog bite cases where I represent the victim. I would say since COVID, my dog bite practice has just escalated so much. There have been so many more dog attacks since COVID. I represent a doctor on the island who was attacked 2 months ago and charges still not have been brought against the owners. My client almost died. He was attacked by a pack of dogs, including a pit bull that severed an artery in his leg. He nearly bled out and died. If the EMTs hadn't been there, he would have died clearly within 3 minutes, or so they said. But my point is, this is such an important bill because the highest crime that a dog owner can be charged with is a petty misdemeanor. So there's absolutely no deterrence. I see time and time again when I go to court with my clients, prosecutors and defense attorneys, plea bargaining, the petty misdemeanor down to a mere leash law violation. That's a violation for injuries that have been inflicted on children with facial disfigurements for the rest of their lives. or in this case, my doctor client, who is still suffering from the effects of this very horrific attack that kept him in surgery for 3 hours, 47 dog bite wounds, 17 staples. We must have greater penalties for dog owners who do not follow the law, who allow their dogs to roam unleashed. I see it every day, all the time. Please do something. I implore you.
Okay.
Thank you.
Thank you very much. Thanks for joining us again.
Thank you for the opportunity. I appreciate it.
That was the last person that we had signed up to testify in person or on Zoom. There's a long list of other testifiers, which I'll read out the stats on. So overall, there were, no, we don't have the stats. Okay, there's several single line pages of support and a couple of oppositions, but almost all in support. So at this point, is there anybody else who'd like to testify on HB 2058? Okay, seeing none. Members, questions? Let's see if I have any here. Oh, yes. Is the public defender here or someone from public defender's office? AG's office? Were you here for this bill? Yeah. Okay, great. The public defender in their testimony said that they thought there was a Modica violation, not because of the internal structure of this bill, but between this bill and the already existing ordinances in the various counties. Is that a thing, or how does that work?
Well, county preemption, state preemption laws from the Richardson versus City and County case would most likely apply. The analysis.
That would just mean that the states would apply, not the county.
If conducting the analysis, then yes, the state's law would preempt the county ordinances.
Okay, but would a prosecutor still be able to charge under either the county ordinance or the state?
Would they be able to? Maybe, but would it stand up in a court of law? That depends on the judge and the preemption analysis.
Okay, so your opinion is 2058 does not need to. We don't need to take into consideration the potential Modica problem.
We can do the analysis to just for if the committee would prefer, but I do understand that the state preemption laws would apply.
Okay, yeah, that would be helpful. We'll hope, if we have the votes, I'll go ahead and move it along, but before conference would be a useful writing data.
Okay.
Okay, great.
Thank you.
Other questions? Okay, let's go and move on to the next bill then. Let's see, that is, HB 2148, relating to campaign finance. This prohibits contributions from persons convicted or found in violation of various campaign finance, ethical, or lobbying offenses. It requires unlawful contributions to escheat the Hawai'i election campaign fund. It requires contributions held by persons who are convicted or found in violation of any of the various campaign finance, ethical, or lobbying offenses to return their respective contributors or escheated. For which this bill? 2184? Sorry, we're working on HB 2184 for those who, if I said it wrong, I apologize. Okay, first up on 2184. Oh, it's a separate list. Okay. All right, here we go. First, we have Candace Park, Deputy Attorney General. Good morning.
Good morning, Chair, good morning, Vice Chair, members of the committee, Deputy Attorney General Candace Park. On behalf of the Department of the Attorney General, we've submitted our comments regarding this bill, In particular, subsection B is ambiguous, and we've suggested revised language in our written testimony. And subsection C appears to be in violation of the due process clause and the takings clause. So we recommended that the committee delete subsection C. I'm available for questions.
Great, thank you very much. Thanks for being here. Next is Robert Harris, Executive Director for the Hawaii State Ethics Commission. Good morning.
Good morning, aloha. Chair, Vice Chair, members of the committee. On behalf of the Hawaii State Ethics Commission, I'm offering comments. The commission as a body has not yet had an opportunity to review this bill. However, staff offer two comments. First being that there is a wide range of ethics violations, and it would appear that this bill, if it moves forward, should take that into account. We recommend, just as a suggestion, perhaps requiring that these be found to be egregious or substantial as just some type of way of distinguishing between that and perhaps someone filing a report a day or two late. In addition, just noting some of the other testimony, there are concerns about the constitutionality of a permanent ban. Having done research on this with regards to lobbying bans, that it should be time limited in scope in order perhaps to survive constitutional scrutiny in the future. Thank you for the opportunity to testify.
Thank you. Next is Kristen Izumi Natao, or Gary, I saw Mr. Kim, General Counsel for the Campaign Spending Commission. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. Commission supports the intent of this bill. We have three concerns. The first one is the permanent ban on contributions upon conviction of a campaign spending violation. Under 11-412, if you're convicted of a campaign spending violation, you're precluded from holding elected public office for 10 years. So there's some kind of limit on how long you can be precluded. The second concern we have is whether or not a civil violation can sustain a permanent contribution ban. That could be helped by making the ban not permanent, but somehow limited, but it's still a civil violation of ethics or the lobbyist law. And the third concern is probably the most important one, is the forced return of the contributions or receipt of the campaign funds. There doesn't appear to be a required nexus between the conviction or the violation and the funds that are to be returned or escheated. I think there has to be some kind of connection. Thank you.
Okay, thank you. Next up, we have Chris Caulfield for Democratic Party of Hawaii Legislative Committee in support, Scott Kidd in support, Greg Misakian in support, Glenn Kagamita in support, and Corey Rosenlee in support. That's everybody who signed up on HB 2184. Would anyone else like to testify on HB 2184? Okay, seeing none. Members' questions? Go ahead, Senator Sinwani.
Attorney General. Aside from what Gary Cam or Robert Harris testified to, my question is your subsection C being violative of the takings of the under the U.S. Constitution. Because when I look at C, it seems to me that we already have like a campaign spending regulation requirement of like within a year or so, and Gary Cam can correct me if I'm wrong, after not running or losing a campaign, they are supposed to already return contributions anyway. So why would a requirement of returning contributions no later than 30 days when there's already a similar provision in the campaign spending rules be considered a taking?
Well,
I could see the other part about this cheating, but you said all of C.
right, because in C, the way it is written, there's a person who's found in violation of subsection A. However, the contributions in this person's account are not necessarily related to any violation. It could have been all received legally. So,
So if this was sort of rewritten, and I don't know, I'm not JDC chair, to basically say that a conviction of a federal or county offense regarding, I guess, regulation of campaign finance, and we'll leave out the ethics or lobbying activities because of the problems Gary Kam and Robert Harris was referring to, prevents that person from running again, or words to that effect, without the other penalties, but then by preventing them from running again, it then triggers the existing regulation. That would be okay.
well, I'm sorry, I'm not very familiar with the law, but if that's what happens when someone decides they're not gonna run anymore, then what's left in their account goes back to their contributors.
Right.
I don't think that's illegal.
Okay.
You know, yeah, it's just that in C, the reason why it's being taken is because this person was found in violation of
Yeah.
something, but there's no requirement that you prove that the money sitting in their account was obtained illegally.
Okay.
Yeah.
Okay, thank you.
You're welcome.
Thank you. Other questions, members? Okay, I don't have any either. I believe that's the end of this agenda. I'm ready to make some recommendations if people are ready to vote.
Okay.
Okay. Going back to the top of the agenda, which is HB 2058 relating to dangerous dogs. The recommendation here is to go ahead and move along with a whole list of amendments, so bear with me as I go through these. Add the definition bodily injury, which is defined in HRS 707-700. Add the definition intentionally, which is defined in HRS 202-2061. Add the definition for knowingly, which is defined in HRS 202-2062. Remove the definition serious injury to any animal. Add the definition recklessly, which is defined also in the penal code. Add the definition of substantial bodily injury, which is also in the penal code. Replace the definition serious injury to any animal with the definition serious injury to, it's a new definition of serious injury to any animal. Replace the term serious injury with substantial injury. I'm sorry, serious injury to any animal with the definition substantial injury to any animal. So we were, yeah, okay. Replace the term serious injury with substantial injury. Replace the term serious bodily injury with substantial bodily injury. This is all basically conforming to the penal code, the current penal code. Remove the definition of bodily injury. Remove the definition of serious bodily injury. Replace language relating to a law enforcement officer's intentional or reckless behavior with language relating to a lawyer's enforcement officer's negligence, gross negligence, or intentional misconduct, as well as acts beyond the officer's scope of authority. Remove a requirement the amount a dog owner needs to pay be the amount specified in a particular subsection. Add a dog owner's right to contest certain costs as something which can be forfeited along with ownership rights over the dog. There will be numerous edits for clarity and consistency. We'll remove the language on page 8, lines 10 to 15, which currently creates a redundancy. In the impoundment section, remove the reference to 143-2.6, but keep references to HRS 142C and 142E. Change the definition of officer to be any deputy, sheriff, deputy, or any member of a police force and animal control officers of the several counties of the state. Okay, well, remove language allowing a private contractor retained by a county to constitute an animal control authority. Additionally, provide that the definition of this term does not apply to any other parts within the chapter. And then we'll also, per the Department of Agriculture's testimony, we'll move the whole thing to Chapter 711, which is in the penal code. And there may be some inconsistencies with what I just stated in the long list, but we will go with changing it to Chapter 711. It has a bad date. We'll put a different bad date on it, April 14, 2021. I mean, 21/12. And yes, questions or concerns? Okay, if not, Vice Chair Gabbard for the vote.
Recommendation on HB 2058 is to pass with amendments. Of the members present, are there any no votes or reservations? Hearing none, the measure passes.
Thank you, members. Next up is HB 2184. This prohibits contributions from persons convicted or found in violation of various campaign finance, ethical lobbying offenses, and some other things. Recommendations to pass with amendments. And this is definitely a construction zone bill, so we'll put a bad date on it to start with, April 14, 2112, and then we'd like to amend Section A to replace person who has been convicted of a criminal offense under Section 11-412 or found in violation of Chapter 84 or 897 or convicted or found in violation of a federal or county offense regarding the regulation of campaign finances, ethics, or lobbying activities with person who has been or caused a government employee to be convicted of a criminal offense involving the acceptance of a bribe. So much narrower definition there. Per the AG's testimony, we'll amend subsection B to read as funds that were received by a candidate committee or non-candidate committee from a person found in violation of or convicted of violating subsection A shall escheat to the Hawaii Election Campaign Fund. Also, pursuant to the AG's suggestion, we'll delete subsection C, which we had discussed somewhat. Then again, somewhat in contradiction to what I earlier said, but this part will preempt it. It will accept the attorney's recommendation. I'm sorry, I'll back up. We'll restrict the application to only criminal convictions so that we don't have people having these penalties for minor violations, as was talked about before. And we'll authorize the Ethics Commission and the Campaign Spending Commission to notify candidates or non-candidate committees of a conviction of a donor to a committee. I'm sorry, of a conviction of a donor under this part, but they will make that notification to a non-candidate or a candidate committee. And as I mentioned before, we'll put a different bad date on it. It's a work in progress. Questions, concerns? If not, Senator Gabbard for the vote.
On HB 2184, the chair's recommendation is to pass with amendments. Of the members present, are there any no votes or reservations? Hearing none, the measure passes.
Okay, thank you very much. That concludes our 10 o'clock agendas. We'll gavel out of those and we'll gavel into our 1010 agenda. First up on 1010 is HB 1911. This appropriates funds for the Judiciary Supplemental Budget for the 2023-2025 fiscal biennium. First up is Brandon Kimura, Director of Policy and Planning for the Judiciary. Good morning.
Morning, Chair White, Vice Chair Gabbard, members of the committee, Brandon Kimura, Director of the Judiciary's Policy and Planning Department, testifying strong support of HB 1911, our Judiciary Supplemental Budget. The Judiciary requests supplemental operating funds for FY25 in the amount of $3.24 million and 4.5 new permanent positions. It's equivalent to just 1.75% of our base budget. We further request $17 million for capital improvements. We crafted this request in late 2023, targeted to leverage areas where modest amounts of funding would have an outsized impact. We're mindful of the budgetary circumstances and challenges, appreciate the House's support of many of our requests, and this committee's consideration as well. I'll now briefly address two downward adjustments in HD2. HD2 does not support our request for restoration of funding for a district family court judge in the Fifth Circuit. That judge has brought tremendous value. We appreciate continued consideration by this committee. HD2 also funds our Olala Hawai'i program for FY25 only and not on recurring funding. Thankful we'll renew our request for recurring funding so the program can make progress and plan multi-year projects. Page 6 of our written testimony addresses several other amendments in HD2, and thank you for the consideration and available for questions.
Great, thank you. Next is Jesse Suki for the Hawaii State Bar Association in support. Next we have Victor Simo, also in support. That's everybody who signed up on HB 1911. Does anyone else wish to testify on HB 1911? Seeing none, members' questions? I have a couple questions for Mr. Kimura if no one else does. So your testimony discusses the lapsing of a couple of funding items. Can you tell us more about what, there was one item that I believe the House Finance forced lapsed, and then there was one that you were suggesting that you lapse instead because you weren't able to get the,
Yes.
it was an IT contract, I think.
So the, in HD2, House Finance forced lapsed $425,000 from last year's lump sum CIP A funds. We're not sure where the 425 amount came from, but again, acknowledging the budgetary challenges that the state is facing, if the intent is to identify funds for this current fiscal year, want to make the committee aware that we are intending to lapse $600,000 that was provided for FY24 by this legislature last session in Act 70. The $600,000 was designated for replacement of our ForGov accounting system. When we issued an RFP in approximately March of 2023, the bids came in much higher. So we advised the conference committee in around April that we would not be withdrawing our request. We received the funding anyway, so we intend to lapse that funding back so that the legislature has that available for FY24.
Okay, thank you. With regard to the Children's Justice Center, which was a CIP request, I believe it was in the previous fiscal year, is that project moving forward?
It is. Thank you for asking. And also in Act 70, we received $6 million for planning, design, and construction, and acquiring land for a new CJC. The headquarters right now, as some may be aware, is in Nu'uanu. It's been there for a couple of decades. It's unfortunately been, although we very much appreciate the opportunity to be in that space, it has not quite met our needs. It's on the second floor. We're leasing the space. It's not ADA accessible. So as an example of some of the challenges that we have when we need to interview children or their families who need ADA accessibility, we're literally interviewing them in their cars in the parking lot. It's a 24/7 operation and needs to be because the types of things that they're interviewing, victims of child victims of sex abuse or other things, has to be 24/7. We do have a satellite office at our Kapolei courthouse. So during business hours, we can use that space. And that's, of course, ADA accessible. But when something is happening after hours, then we have to have it happen there. So we've been looking for a place for years. We are moving forward with the $6 million. We've handed the project over to DAGS, but are working with DAGS and also with the DOE on possible site selections. We've been visiting sites as recently as yesterday. And we're hoping to move forward with a consultant and design.
Okay, thanks very much.
Thank you.
Other questions, members? Senator Elefante, go ahead.
Yeah, thank you, Mr. Kimura. One question I have, I believe this is at Ka'ahumanu Hale on the ground floor, where it was kind of gutted and replaced in some areas that moved and relocated. Are there future, I think that might have been for probation or interviews. Are there any future plans for that? And is that included in this budget?
It is not included in this budget. Just to share a little bit of an update. So there are a few things going on in that atrium area. One is the funding that the legislature provided recently for a redo of the sheriff's station. So that's on the, if you're heading into the building on the left side, to expand that station, make it a little larger, make it more appropriate for their operations and safer for the building so that members of the public can't just walk by and see what they see on their security screen. So that's one project. The other project is if you're walking in to the building on the right side, where we have some operations staff. We've got a service center there that's, sort of makeshift, but we hope to make that a little more robust with existing funds. We don't have the request here. We're also looking at other things to improve that atrium space and make it more functional.
Okay. Thank you. Thank you, Chair.
Thank you.
Thank you. Other questions, members? Thank you very much. We'll go ahead and move on to the next bill, which is HB 2802. This proposes constitutional amendment to repeal the legislature's authority to limit marriage to opposite-sex couples. First up on 2802 is Jill Takuda, Congresswoman from the 2nd District. In support, next is Congressman Mark Takano from California, District 39. Also in support, Blake Oshiro, Senior Advisor for the Governor. In support, Constance Yonashiro for the Hawaii Civil Rights Commission. In support, Michael Formby, Managing Director, Sitting County. Also in support, Rick Blangiardi, Mayor of the Sitting County of Honolulu. Also in support, Matt Ware, Council Member for Sitting County of Honolulu. In support, Nikos Leverance, Grants and Advancement Manager for Hawaii Health and Harm Reduction Center. Good morning. Followed by Michael Galoyo Jr.
Good morning, Chair, Vice Chair, members. My name is Nikos Leverance with the Hawaii Health and Harm Reduction Center. In the late 90s, Life Foundation founder Dr. David McEwen was involved in the campaign that encouraged people to vote no on this back in 1998. H3RC is a successor organization of Life Foundation and the Chow Project, and we've been working with our partners at the ACLU, the LGBTQ Legacy Foundation, Council for Native Hawaiian Advancement, and Papa'ololokahi to sort of correct that historical wrong. Section 23 constitutes a problematic provision that empowers the legislature to discriminate against against same-sex couples in favor of opposite-sex couples. So we strongly support this bill. We also ask that the bill be unamended. It's a straightforward repeal, and we fear that asking voters to repeal and then do something else affirmative might be confusing and result in undervotes. Mahalo.
Thank you very much. Next is Michael Galoyo Jr., Chair for Stonewall Caucus of the Democratic Party of Hawaii. Good morning.
Good morning. Michael Galoyo Jr., Chair of the Stonewall Caucus of the Democratic Party of Hawaii. We thank you for hearing this bill. This bill is not just about marriage equality and the right to marriage. It's about the enshrining in our state constitution the right to discriminate. The first time and only time that's ever happened in this state, and hopefully the last. This bill is about making sure that we protect the LGBTQIA plus community. This bill is about making sure that we let them know, that community know, that they are honored and respected in this state. A lot has changed since 1998. You'll see it in the testimony today that we have labor behind us this time. We did not have that in 1998. You will see the different, we have Congress people behind us. We had our US senators behind us in 1998, and now we have our Congress people behind us. We encourage you we did in our testimony ask you to amend the bill, because this bill does not lead, it takes us back. It does take us back to a time that brought us Bear v. Lewin decision, the first triumph in the fight for marriage equality. If you want to lead on civil rights when it comes to these issues, we encourage you to amend the bill to take in the language that was permitted by the Equality Caucus version, because that actually takes us a step forward and also protects not just same-sex couples, but interracial couples. Because we know with the makeup of the Supreme Court, Loving v. Virginia is on the chopping block, and Oberveld v. Hodges. And let's be quite clear, this is not about Oberveld v. Hodges. We passed marriage equality because of US v. Windsor, and that was done. So I'm not worried about in our state, thanks to the leadership of President Biden and Speaker Pelosi at the time, with the Respect for Marriage Act at the national level. We are protected here in the state. So we encourage you that this bill is not just about marriage, it's about respect, it's about honoring, and it's about taking care of this community. So thank you.
Thank you very much. Next is Osa Tui, President for Hawaii State Teachers Association on Zoom.
They're not present on Zoom, Chair.
In support, next is retired Intermediate Court of Appeals Judge Daniel Foley. He's on Zoom. Oh, okay.
Members of the committee, thank you for the opportunity to support this bill that would allow the voters to vote once again in Section 23, whether it should remain in Article 1 of our Constitution or be removed. Section 23 is the only section of the Bill of Rights ever adopted to take away rights. The only provision ever adopted in the Bill of Rights to discriminate against the minority. And it's directly contrary to the ruling of the U.S. Supreme Court in Obergefell versus Hodges. As previous testifiers have mentioned, much has changed since November of '98. November of '98, there was no same-sex marriage anywhere. Now it exists in 50 states and 37 countries. In November of 1996, we had the Defense of Marriage Act, which rejected same-sex marriage. Now we have the Respect for Marriage Act that recognizes same-sex marriage. And public opinion has gone from 2-to-1 against to 2-to-1 for. So all this bill does, voters to vote once again to remove this section. It will be up to the voters, but I think we've learned a lot in the last few decades, and I think they'll vote for civil rights, for inclusion, and against discrimination. Thank you, Mr. Chairman.
Thank you very much. Next, we have Abby Simmons for the co-chair of the Legislative Committee for the Democratic Party of Hawaii.
Mahalo, aloha, Chair Rhodes, Vice Chair Gabbard, and members of the esteemed committee. My name is Abby Simmons. I'm the co-chair of the Legislative Committee of the Democratic Party of Hawaii. And I'm here today to testify in strong support of HB 2802 on behalf of the party. The Legislative Committee has identified this bill as one of our top priorities for this session. We firmly believe this constitutional amendment is needed to protect our fundamental human right to marry who we love, regardless of race or sex. A right that has really been called into question by some members of the Supreme Court, and sadly, the current state of extremist and divisive politics. We humbly ask for your support of this bill. Mahalo nui loa for your time and consideration.
Thank you. Next up is Josh Frost, Policy Assistant for the American Civil Liberties Union of Hawaii. Good morning.
Good morning. Good morning, Chair Rhodes and committee members. My name is Josh Frost. I'm a Policy Assistant at the ACLU of Hawaii. For many of us in the room today, 2802 ends a journey that began in the 90s. For the legislature, it closes a frustrating and disappointing chapter in its history. One of the earliest lessons I learned, and maybe the hardest as an advocate, was to not let the perfect be the enemy of the good. With the passage of 2802, we can collectively have a chance to set right a very big wrong. I urge you to pass out this bill unamended. Please don't allow the bill to have a chance to die in conference. It can redeem the legislature and doesn't need to be improved. Let's get it done. Let's put this question to the voters so they can redeem the state and we can once and for all move on from this dark chapter in our state's history. Let us remove the mean and bigoted language that exists currently in Article 1, Section 23. Its repeal will ensure no discrimination on the basis of sex in marriage in Hawaii. HB 2802 is rooted in our shared values of fairness and equality. Once again, please don't let the perfect be the enemy of the good. Please pass the bill unamended. Mahalo for the opportunity to testify.
Thank you. Next up is Sarah Kamakavigo Ole for Papaola Alokahi on Zoom.
They're not present on Zoom, Chair.
In support, next is Jeffrey Hong, Coalition Chair for Change 23 Coalition. Good morning.
Morning. Aloha, Chair Rhodes, Vice Chair Gabbard, and members of the committee. My name is Jeff Hong. I am the chair of the Change 23 Coalition. We're a group of civic organizations advocating for the repeal of Article 1, Section 23 of the Constitution. And I'm overjoyed to be here. Senator Rhodes, it was over 10 years ago that I stood in front of you and members of the legislature on the topic of marriage. I was excited, nervous. The opposition was chanting, "Let the people vote." And I thank you and members of the legislature for your patience and wisdom to reject exercising the authority granted by the Constitution to limit marriage. If we go back 25 years ago, I could not speak at those hearings. As an officer in the Hawaii Army National Guard, a public declaration of my desire to marriage would have been considered self-incriminating evidence at my court-martial. We have come far in 25 years, but the caution from Dobbs is that in 50 years, the pendulum could swing full circle. I read yesterday that support for same-sex marriage dropped last year nationwide. We know this current US Supreme Court would not have recognized our rights, and some members actively advocate for repeal. Our state constitution is modern and was meant to be aspirational. We have an equal rights amendment that's still lacking in the US Constitution. And from this document, our freedom to marry was implied and recognized. The legislature and the people of Hawaii chose to explicitly constrain this implied right. We ask you to repeal the discrimination of a previous era and to restore the aspirational nature of our Constitution, and then to let the people vote. Mahalo.
Thank you very much. Next up is Jeff Esmond for Hawaii State Commission on Fatherhood. Good morning.
Good morning. Chair, Vice Chair, Senators. Thank you for allowing me to be here today. My name is Jeff Esmond. I'm the Chair of the Hawaii State Commission on Fatherhood. The Hawaii State Commission on Fatherhood serves in an advisory capacity to state agencies and makes recommendations on programs, services, contracts, policies, and laws relating to children and families. And those keywords are children and families. We had our monthly meeting last week, and the majority of our quorum is in support of repealing this amendment. We believe that all children should have a right for their parents to be married and to have a family that's recognized legally. Thank you.
Thank you. Okay, that's all the organizations and individuals who signed up for Zoom or in person who wanted to testify in HB 2802. There's many other people who submitted written testimony, 192 in support, 1 in opposition, 1 comment. So at this point, I will open it up to anybody else who wants to testify, but first let me ask if Justice Levinson wants to say anything.
Thank you, Chair. I'd be happy to answer any questions.
Okay, all right, thank you. Anyone else wishing to testify in HB 2802? Come on in. Good morning.
Happy solstice. Happy spring. I come to you today as the founder and president of Rainbow Family 808. We are new in the area. We've only been here since 2012, 13, when we passed marriage in Hawaii. I thought it was done. I forgot about the little menahunis that sit out there and think of new ways to.
Tell us your name.
Oh, my name.
Yes.
My name is Carolyn Martinez Annette Galoyu. Also Hart, my father, my birth father. Anyway, I'm here because I have a gay son. I've been here since January of 1996, testifying for the civil rights, not only of my gay son, but for all my friends I've made along the way. I love each and every one of them, and I ask that this body, in its ideals of justice, in its ideals of equality, take care of this once and for all. Get it out of our Constitution. It has no right there. I dedicate this speech to 2 women. While we were fighting in this very building for marriage rights, one of them was, there were 2 lesbian women who'd been together over 25 years, but Queens wouldn't allow one of them into the ICU because they weren't married. They had no legal right. So the other sat on the steps outside of Queens and cried. She ended up with an episode, heart attack, I don't know. But I dedicate this to them because they didn't have rights back then. You can no longer allow this disservice to all of our taxpayers, to all of our people.
Thank you so much.
Okay, thank you very much, and
Anyone
thank
else
you for
wishing to-
even hearing me, because
Next. Anyone else wishing to testify in HB 2802? 2802.
Pride at Work wants to go on record as full and strong support. We're sorry our testimony is late.
Okay, pride at work and support. Okay. Anyone else? Okay, seeing none. Members, questions? Senator San Buenaventura.
I'd like to have Josh Frost and Nicholas Leverance up. So I understand your testimony that you folks wanted as is and not the amendment referred to by Michael Galoyu Jr. of SB 2884 language. And my question is, not necessarily why, but it is why, because if we just pass it as is, And in the event the US Supreme Court reverses the prior decision, then the status quo in Hawaii is civil unions, not marriage. And I see Michael Levinson is saying no, but that was my understanding, was when this constitutional amendment was passed, the legislator passed civil unions, okay, and not marriage. Go ahead, Nikos.
Aloha, Senator San Buenaventura. I will defer to Justice Levinson on the question of the prevailing constitutionality of same-sex marriage under our state constitution. But I believe, if I can state that clearly, a prohibition against same-sex marriage would be found to be unconstitutional under Article 1, Section 3, which provides that the state cannot discriminate on the basis of sex. This gets back to kind of the heart of what Judge Chang ruled and what Justice Levinson ruled. And I will not speak for Justice Levinson.
And I will ask him, because he's the one who's
but
vehemently.
if I could get to how we came to this position here, as you may be aware, we started talking about this basically last summer. I know that there have been ongoing conversations within the party and within the Stonewall Caucus, but my involvement in this first started in July, where it was announced at a Legacy Foundation fundraiser, and we had a lot of work to do in terms of developing language, and we worked with the Equality Caucus over that time to develop language. We did not get adequate language until the final days of the session. So, and then we got the so-called clean repeal on the very last day a bill could be introduced.
So that's the reason why.
So that's the reason why we support a clean repeal as opposed to something that is more encompassing, that was offered by the Equality Caucus.
Okay.
So if
anything further to add, then I'll go ask. May I ask Justice Levinson then? Okay, Justice Levinson, come on in. And I know you are the architect of the Hawaii Supreme Court decision. Why is it, my understanding is, if the US Supreme Court repeals, and I don't remember that case, where it gave marriage equality.
Obergefell, I believe, Senator.
Right. If we reverses that, don't we go back to civil unions, or you're saying we don't? Why not?
We don't go back to civil unions because of the doctrine of state constitutionalism. And generally what that doctrine says is that states are free to afford greater protections to their citizens.
Okay, but we're back to the state Supreme Court interpreting the Equal Rights Amendment to encompass marriage. So don't we then put it back into sort of jeopardy? I know Hawaii is more liberal than most, but in the event we have a conservative majority in the Hawaii Supreme Court, don't we then risk an interpretation that reverses your opinion? And instead of having it clearly, if the voters are going to vote for a constitutional amendment anyway, why don't we make it clearly that marriage equality is going to be part of the Constitution and not just a repeal where Hawaii Supreme Court justices may decide or reverse themselves?
I have, as Senator, I have no objection in the abstract to an express recognition of the right against discrimination with respect to access to the legal status of marriage on the basis of sex or anything else protected by the Hawaii Constitution's Equal Protection Clause and the other provision in our Bill of Rights, which presently prohibits sex discrimination on the basis of sex, but for Article 1, Section 23. As long as the Hawaii Bill of Rights guarantees equal protection of the law, which prohibits access to the legal status of marriage on the basis of sex, that should be sufficient protection.
Okay.
It speaks for itself. I think the general concern from our end, and I say that collectively, is that adding the affirmative protection as the proposed amendment to the amendment would run the risk of forcing them, would force the matter into conference committee, and then would raise the specter of the matter dying in conference committee.
Okay. Thank you.
Thank you.
Other questions? I guess I do have one question. So at this point, there's several things. If we pass this and the voters approve it, which of course are not automatic, then there is SB1 HD1 is on the book still. So you'd have to get rid of that somehow, just in terms of the layers of legal protection. So there's a statute, there's what you already talked about in terms of equal protection under Hawaii law, and at the moment, the feds still support equal protection that covers same-sex marriage at the federal level as well. So there's really, is it fair to say there are at least three fairly major changes that would have to occur for same-sex marriage to be in jeopardy again?
I suppose so, Senator Rhodes. I think the major risk is that the United States Supreme Court might overrule Obergefell. And if it overruled Obergefell, that would create a problem regarding federal protection. But it would not affect existing protection at the state level, at the Hawaii level, because states are free to afford greater protection to their citizens than are provided under the United States Constitution.
Okay, thank you. Other
Thank you.
questions, members?
Yes, I do. Sorry.
Senator San Buenaventura, go ahead.
Yeah. And I know we have session, so I'm gonna ask you to make your answer quick. So, if the court reverses Obergefell, and basically under your interpretation, and if we pass this clean, we still have marriage protection in Hawaii Constitution. Will other states be required to provide full faith and credit to our marriages? It's my understanding that they have to, just like they do common law marriages. We have to accept common law marriages, other states.
I believe that they would have to, unless the United States Supreme Court were to rule that they didn't have to.
Right, that's right. Okay,
All right.
thank you.
Thank you.
Other questions, members? Okay, if not, I'm ready to go to decision-making if everyone's ready. Okay. First up on this agenda was HB 1911. This appropriates funds for the judiciary's supplemental budget for the 23 to 25 biennium. The recommendation on 1911 is to pass with several amendments. We'd like to restore funding for a Fifth Circuit District Family Court Judge that was requested in the judiciary's initial bill. Also establish an operating budget for the Alelo Hawaii program on a recurring basis. The bill currently makes a one-time appropriation. We'd like to provide a CIP lump sum operating with A funds for fiscal 24-25, not C funds as currently in the bill. And we'd like to restore the forced lapse of the $425,000 of lump sum operating A funds for CIP in FY24, and instead lapse the $600,000 in operating funds in Act 70 from 2023 for a new accounting system, which the testimony was that wasn't enough to cover what they needed. I'd like to include a no-cost conversion from temporary to permanent for a court operations specialist position in the Court of Appeals. This is the Intermediate Court of Appeals. Is this the Intermediate Court of Appeals? ICA or in the clerk's office? Okay, in the clerk's office. And let's see. We'll go ahead and put an effective date of July 1, 2024, but of course, it's quite different from this would be quite different from the House version, so it'll probably go to, it will go to conference anyway. Okay, so we're deleting the forced lapse and restoring the lump sum of $425,000, just to be clear that that's what we're doing. Questions or concerns? If not, Senator Gabbard for the vote.
On HB 1911, Chair's recommendation is to pass with amendments. Of the members present, are there any no votes or reservations? Hearing none, the measure passes.
Okay, thank you. Next up is HB 2802. This proposes a constitutional amendment to repeal the legislature's authority to limit marriage to same-sex couples. Recommendations to pass as is. Questions or concerns? Senator Gabbard.
Yeah. Chair and our guest, I want to take this opportunity before I vote to sincerely apologize. As some of you know, I played a critical role in the passage of the 1998 Constitution Amendment. So I want to say to you publicly that I'm sorry. I am sincerely sorry if I offended you in any way. And that comes from the bottom of my heart. So please accept my apology. My views on marriage have changed over the years. I don't believe government has any business in telling people who they can and they cannot love. And I was on the way here from Kapolei, I was all set to vote no on this measure today, but I still have some issues that have not decided yet. So I'm going to vote with reservations today on this measure. So thank you, Chair.
Thank you. Other comments or concerns? If not, Senator Gabbard for the vote.
On HB 2802, this is as is?
As is.
Chair's recommendation is to pass as is. Of the members present, are there any no votes or reservations? Reservations for the vice chair. The measure passes.
All right, thank you. Our 1010 agenda is concluded and we're adjourned.